Good afternoon and welcome to today's panel session where we are joined by industry experts to answer your questions from the recent site inspections and enforcement webinar. My name is Andrew Cellini and I'm the State Building Surveyor. Firstly, I'd like to acknowledge the traditional owners of the country on which we meet today and pay my respects to their elders, both past and present, and I extend that welcome to any Aboriginal or Torres Strait Islander peoples who may be here today. Back in May, we hosted a session on this topic and were overwhelmed by the engagement in polling and question and answers and in response to the content presented. It was also our most popular session to date with almost 1,200 practitioners tuning in and really demonstrates a broad cross-section of practitioners that were interested in the topic. We had a healthy mix of building surveyors, inspectors, engineers, designers and builders all actively engaging with the content, and we realised the topic was deserving of an additional session to try and clarify some of the lingering confusion in this area. Thank you for tuning in again and for posing such a wide range of questions to keep the discussion going. And I'm really excited that we've got Bronwyn back again to really explore some of the obvious areas that need filling. Our aim today is to discuss in more detail some of the top ranking and important questions you had. And as I mentioned, we've got Bronwyn here to assist us, as well as Dr. Baya Zagul and Alicia Prince. Many of you will know Bronwyn from previous DBA webinars and MC of this year's Building Surveyors Conference, and of course as co-author of the Building Confidence Report and Managing Director of Weir Legal. Baya joined my office in April this year in the role of Principal Structural Engineer. Baya adds to the technical capabilities of the Office of the State Building Surveyor, with the VBA now having building surveying, fire engineering and structural expertise to assist with responding to industry needs and actively participate in shaping and implementing future reforms. Baya is a fellow and chartered engineering executive of the Engineers Australia and has strategically planned and directed major multidisciplinary projects, including building and civil works, transport, water and health infrastructures. His past experiences includes the State Structural Discipline Leader and Director of a large national and international engineering company. And he is also a Research Fellow of the University of Canterbury in Christchurch, New Zealand. Alicia Prince is a Chartered Civil Engineer and the General Manager, Victoria, of Engineers Australia, Australia's peak engineering association. She has extensive industry experience based on a career focused on the design, construction and delivery of major infrastructure projects. She has been heavily involved in representing the interests of the engineering profession in the development of the Professional Engineers Registration Scheme that has recently been introduced by the Victorian Government. Before I hand over to Bronwyn to facilitate the panel discussion, normally we would encourage your questions via the Q&A function. However, as this session is dedicated to answering your questions from the previous session, we won't be addressing live questions today. That being said, you're welcome to post any questions you have, as it provides valuable feedback on the topics and areas of interest to help us inform future webinars, educational resources and reform discussions. Finally, the session is being recorded and will be available on the VBA's website and YouTube channel. I'll now hand over to Bronwyn to get started. Welcome, Bronwyn.
Thank you, Andrew. And also welcome to our other panellists today. As Andrew mentioned, we have Dr. Baya and Alicia Prince here today on the panel. So if I could ask you to turn your cameras on for our panel members. So just by way of introductory comments, this is a follow-on session from the one that we ran almost 3 months ago back in May. So we had dozens of questions, and I must say that the quality of the questions was really impressive, showing that there was a strong engagement in the topic, but also a lot of detailed thinking behind some of the questions and getting into the next level, I guess, of detail and query about how the inspection process works under the Act, and also more broadly the role of inspecting building work during construction by different practitioner groups. So we've done our best to draw together, I guess, themes of those topics. We've also reproduced word for word specific questions that were raised so that you can see the question, and we'll answer questions individually, as well as doing sort of presentation style answers to some sort of more groups of questions, and using the expertise we have on the panel today to discuss some of the answers to questions as well, because sometimes the Act doesn't provide the answer, which might be why the question's been asked. And so it requires some discussion and consideration of ways in which you might approach a particular query that has been raised for discussion today. So we're going to start with a selection of questions which were around trying to really understand who can do inspections that are not mandatory inspections under the inspection process that goes with the building approvals process, and also that sort of gnawing question about unregistered inspectors and what they can do, or the extent to which they can participate in the process. So the first two questions on the slide there are really about those things. Who can conduct inspections that are not mandatory notification stages? What the Act says is that if you're doing an inspection that's required by a relevant building surveyor, as a building inspector or a building surveyor, you need to be registered to do that work. So if it's a non-mandatory inspection, but it's required by the RBS, you need to be registered. If it's a non-mandatory inspection and it's not required by the RBS, so for example, it's being requested by an owner or a builder, those sorts of things, then the Building Act doesn't deal with those sorts of inspections. However, we do have the professional engineers legislation, which now requires registration for engineers. And so if you're doing an inspection as an engineer, you are required under that legislation to be registered. There is an exemption for direct supervision of engineers, which we'll discuss more during the session today. So in terms of who can conduct inspections, we still need people to be registered where they're related to the RBS requests, or where you're acting as an engineer and providing engineering services, you need to be registered under the new legislation for engineers. And you need to have an endorsement to do work in the building sector. And again, we'll come back to that. When can an unregistered inspector inspect? Now here you can only work as an unregistered inspector under the physical supervision of somebody that is that you're working to. So perhaps you're seeking to gain experience so that you can become registered. So if you're going out on site, you need to be going with a registered person to do those inspections. You can also work as an unregistered inspector if you're working for the VBA as a public service authority. In the last session, I said that that if you worked for council, you didn't need to be registered. That wasn't correct. So we all make mistakes, and I'm owning that one in this session and making a correction. So it's public service authorities can have unregistered inspectors, which would include the VBA, but not councils. So otherwise, you need to be physically supervised, or you need to be working for the VBA. Can unregistered inspectors work under a registered building inspector? Well, yes, you can. And this really goes to this question of, how can you inspect? So can you, do you need to physically be on site, or can an unregistered person go out and collect information which they present back to you in your office or via technology, and you view that material to do the inspection? And the answer is that in some cases you can use those virtual or remote or supervised inspections, in which case there might be a role for an unregistered person to assist with the inspection that is done by the registered person. Okay. I'm going to reinforce some of that in a second with a table, But before I do, I just ask the panelists if they want to comment on any of what I've said so far.
From my perspective, Bronwyn, I think the distinction is around those mandatory and non-mandatory. That mandatory inspections, it's quite clear in the legislation that it's got to be in person, and so I think that does cause issues with things like remote video inspections currently, and that's something that is being looked at more broadly, but. And then, the interpretation of how that works for engineers and their direct supervision criteria, I think would be interesting to discuss a bit later.
Yeah. Now, just the third question on this slide was specifically to do with the pool safety inspector category. Can we explain the requirements for inspectors? So what we have with regards to pool barrier inspections, which now there's a whole regime for those to occur in Victoria. So a registered surveyor or inspector can do pool barrier inspections, but what has also now been created is a new category of inspector, which is a pool safety inspector. So the people who have registration in that class of inspector can only inspect pool barriers, not other classes of buildings or buildings more broadly. So if you're looking at the inspection, the registration of a pool barrier inspector, a pool safety inspector, you need to also look at whether there's any conditions on their registration. So in some cases, the VBA has been issuing registration to the pool safety inspectors, but limiting their scope of work to certain pool safety barrier standards. So they can only inspect pool barriers of a certain age to which a certain standard applies. So it's something to be careful about if you're looking at whether the pool safety inspector that's done the work is properly registered, is to make sure that you're having regard to any conditions. But otherwise, they are a limited scope of registration for pool barriers only. But as I said, if you're registered as a building surveyor or an inspector in that broader category, then you can inspect pool barriers as well as the other classes available under your registration. So just to recap what we've been saying about inspectors, we thought that a sort of a more comprehensive way of talking about this, and this table really covers a number of questions that came in about these issues of different sorts of inspections, who can and can't do them, who needs to be registered, when can you use someone that's unregistered to assist with the inspection. So the first row there is about inspections at mandatory notification stages as part of the building approvals process. And that would include any inspections that relate to directions to fix that have been issued as a result of a mandatory inspection. So who can inspect those? The relevant building surveyor must cause all of those inspections. So they must be involved in all of those inspections in making sure that they're occurring and in who's actually conducting the inspections. The Act says that only a registered surveyor or inspector, subject to their class of registration, can inspect, or prescribed engineers or prescribed work. So if you're not sure what those prescribed works and engineers are, then that's in Reg 174. And we talked about that in the last session. So it's only these people that can do inspections in the mandatory inspections. And in the case of engineers, it's limited to certain sorts of work that different classes of engineer can inspect. They must be endorsed now under the new professional engineers legislation and registered under that scheme. So the mandatory inspections must be done in person. So it's here that you cannot use anyone unregistered to assist with those inspections. They must be attended in person, and that is the firm position of DELP in relation to mandatory inspections. And as we mentioned in the last session, there must be a report prepared under 35A. The prescribed requirements of that report are in the regs 173. There can be a request for a 238 certificate for these inspections. And if it's domestic building work, then a 238 certificate can be issued, okay, by the engineer. So domestic building work is defined in the Domestic Building Contracts Act. It includes multi-storey residential work, but it is domestic building work that the 238 certificates are issued for. So the certificates are not mandatory, but they can be required by the building surveyor. And you might have an authorisation given to either an inspector or a surveyor who's doing inspections to issue directions to fix. Where an RBS is causing some other sort of inspection that is not for a mandatory notification stage, you still need to have a registered building surveyor or inspector, and you would need to be a building endorsed engineer and registered in an appropriate class for whatever it is the RBS is asking you to do that inspection for. Okay, those ones don't need to be done in person. So this is where you may be able to have a virtual inspection, or you maybe have someone who's unregistered who attends the site and collects information or takes you through the site using technology via some sort of video link. And so you would be doing that work under supervision. The other types of inspections are contract inspections by engineers. So this is where they're not mandatory, but they're being done as part of a scope of work with the engineer. And they might be being done at different stages of the design work, the structural work, for example, where the structural engineer has agreed through their scope of work with the builder or the owner to do those inspections in addition to the design work. So in those cases, we're talking about engineers registered under the new legislation. They have to be building endorsed engineers. Those inspections are not governed by the legislation, so they can be in person or they can be done under supervision. And what you should take note of if you're an engineer is that there are guidelines on what direct supervision means, and they're found on the Consumer Affairs Victoria website. If you Google the professional engineers legislation there's a number of really useful guidelines, and that tells you how you can directly supervise others to do engineering work. For councils doing enforcement or compliance inspections, so again, these are not mandatory inspections, but there may have been a complaint or there's some inspections to do with enforcement. So where the MBS becomes an RBS, and you need to look carefully at the definition of RBS in the Act, then those registered surveyors or inspectors must be used. But again, like the inspections above for the contract engineers, they can be done virtually or in a supervised manner by sending out other people to gather information, and then it's the MBS or the registered building surveyor back at council who can view all of that information to carry out the inspection via information. In the other series of questions was about the inspections that are done on behalf of owners. So it seems to be becoming more common that an owner wants their own person to do inspections side by side or in tandem with the relevant building surveyor as their own safety net, I suppose, or some other level of assurance that they're paying for directly. Or they might be getting inspections to do with alleged defects or at other stages of the work that they're arranging themselves outside of the formal building approvals process. Those inspections are not governed by the legislation. Any person can do them. You don't have to be registered to do those inspections. If you're doing them as an engineer, then they probably fall into the category up the top row there. But if you're doing them with some other sort of building background or something like that, you don't need to hold a particular category of registration for that. However, if you do take on that work and you do it because you're registered, and that's part of the expertise you offer and what the owner is paying for, the registration experience that you hold, then anything you're doing as a registered person is subject to disciplinary action. And certainly if you're a registered building surveyor and you're giving these consultancy services to owners, then you would be bound by the Code of Conduct. Did any of the panellists want to add any comments to that before I move on?
I can start, Bronwyn. So I think for me, once again, it's that clarity that's important around mandatory versus non-mandatory. So I think that's where a lot of confusion does occur. That the mandatory is very inflexible in the legislation, so it does require that registered practitioner, registered building surveyor or endorsed building engineer to be involved in that inspection personally on site. Once it's not mandatory, then it still requires the registered building surveyor or endorsed engineer to be responsible for that inspection. So it's up to them to really supervise. So they either attend in person, or they need to satisfy themselves that the person that is attending is providing enough information to them. So whether that's via that sort of virtual mode, or whether they're supervising them on site, or whether they're accepting photos, etc. They're all things that the registered party is really responsible for. So they need to feel confident that that information that's coming back to them is enough for them to make their decision and to support it with their registration.
Alicia?
Just to reiterate that point, Bronwyn, about the professional engineers registration scheme, that does mean that all engineers who are providing a professional engineering service need to be registered, unless they're working under those requirements of direct supervision. So we can talk more about that as we go through, but I did stick into the chat the link to the Consumer Affairs Victoria website for anybody who actually wants more detailed information.
Thanks, Alicia. All right, now we're going to talk about what does causing an inspection mean, and we had a series of different questions that really went to this point. There's three key elements to what causing an inspection means. So here we're talking about the mandatory inspections under the building approvals process. So firstly, the RBS must be notified. The Act requires it. It is not negotiable. There has to be a notification when calling for the mandatory inspection. So that's the first point to note. Causing an inspection means the RBS has to be notified that that inspection or the work is ready for that inspection. The RBS needs to know who's going to do that work. So if the builder's putting forward the engineer, the contract engineer, to do an inspection of some component of the work, the RBS has to know about who that person is. Are they appropriately an endorsed building engineer and holding the right class of registration to allow that scope of inspection? Do they have the right expertise? So not just registration, but are they appropriately experienced to be looking at the work on this type of class of site, for example, class of building? Are there any conflicts of interest? And we are going to hone in on that issue for those of you who ask questions about the role of a design engineer and whether there's an inherent conflict in them doing inspections. We're coming to that, but that's certainly a consideration. The RBS also ultimately has the discretion over who's going to do this work. So a builder can't demand that a certain engineer or inspector be used. It's the RBS's decision as to who is going to do those decisions, and they have a discretion. The third element is around the process for inspecting. So there has to be some sort of engagement between the RBS and the person who is going to inspect in order to know what does the RBS want in terms of that prescribed and mandatory report. Is that going to be provided through some sort of IT platform, or is it going to be done on a form that the RBS wants the inspecting person to use? How quickly do they want that to be sent through after the inspection? Are they also asking for a Section 238 certificate for domestic work? All of these things need to be understood by the person who's inspecting in terms of what's being asked of them and how they conduct that inspection for that particular RBS. Also, what is the process where there's a non-compliance? So if the inspecting person is a surveyor or an inspector, are they going to be issuing oral directions to fix? If it's an engineer, what is the communication that is expected between the RBS and the engineer where there's a problem on site? if the engineer is going to issue an instruction or has some concern about the work, how does the RBS want that communicated back to them? How quickly, so that the RBS can ensure that they are on top of any problems that are identified during inspections, and whether the DTF process needs to be activated, for example, or whether you need to call for a revised engineering, or what it is that's going to resolve the issue that's been discussed. Any comments from the panel on that one?
Yeah, thanks, Bronwyn. I think this slide is really all about communication. So it's really the communication lines between the various parties, and I think that's something that isn't working as well in some circumstances in industry in practice currently. So, and I think part of the issues are the sort of the contracting arrangements and the lines of reporting, if you like, that quite often the builder will contact the engineer to do the inspections, and then the engineer will do those inspections and report back to the builder. So it's really important to understand that the legislation requires the building surveyor to play a key part in that process, that the building surveyor should be notified of that inspection, and basically have the opportunity to confirm that whoever's doing that inspection is appropriate, and accept their registration, qualifications, etc. And then it's equally important at the stage that the engineer goes out on site and identifies issues, that they don't just communicate that back to the builder or the owner, that includes the RBS. The RBS then needs to consider what action they might need to take in relation to that. And it could be that the instruction from the engineer actually requires variation on the building permit. So that is an important piece to sort of consider in the process, that there is a risk that if the building surveyor is not included, and this is probably inclusive of outside of the mandatory inspections too. So if there is engineering inspections that are occurring during the construction process and there's things identified, there should really be a consideration of notifying the RBS of those particular issues, so that they can decide whether there's a variation required. It may also impact other building code requirements as well, so the engineer themselves may not be aware of implications for other parts of the compliance requirements under the building code. So hence, once again, very important to make sure that the building surveyor is kept in the loop.
Alicia and do you want to comment on that?
I was going to make a comment that timely communications is really important, because nobody wants to have to do rework. So rework can be really expensive. If communications can happen early, there may actually be a chance to catch some of these issues before work's actually implemented, and that's a positive benefit for everyone, for the builders and for the community, to be able to catch some of these issues early. So I'd just be encouraging everyone to make sure they're having those open conversations and sharing the information, and keeping the building surveyor in the loop as to what's happening, so the right decisions can be made for the project.
Just on this next slide, a couple of more specific questions that came up about the cause to inspect provision. When a builder emails a request to the engineer and CCs in the RBS, is that sufficient to cause an inspection? I guess the issue with this question is it's not up to the builder to decide how the inspection is going to be caused. It might be that through that process of dialogue between the building surveyor and the builder and perhaps the engineer as to how these inspections are going to be arranged, that it is agreed that you can CC the builder in, but that's got to be part of a discussion or an understanding as to, if that were the case, then the RBS would already need to be satisfied that this engineer is appropriate, that they have some communication with the engineer about the issuing of the mandatory reporting, whether the engineers are going to be asked to issue the 238 certificate for the work. So merely sort of saying, well, can you CC in the RBS? Maybe. if the RBS is satisfied and happy with that as a process. But if that's all you're doing, then that's not going to be enough for the RBS to be able to discharge their responsibility around causing an inspection. The other one is who should be paying for the inspections, because they're being conducted as part of the mandatory inspection process and they're being caused by the RBS. Does that mean that the RBS should be paying directly for those, or can the builder pay, for example, for the engineer, or perhaps the scope of work of the engineer includes the cost of those inspections? The answer from the legal point of view is that the Act doesn't require the building surveyor to pay for those inspections, and nor does it necessarily imply that that's mandatory or that has to happen. So again, it's a bit similar to the first question. Merely copying in the building surveyor may or may not be appropriate. Whether the inspection's being paid for by the building surveyor may or may not be appropriate. It really depends on how the RBS wants to manage this process and whether or not they want to engage directly with, under contract, these inspectors, or whether they're willing to have the contracts between, say, the builder and the engineer include the mandatory inspections, and therefore there's no sort of payment passing between the RBS and the engineer in those circumstances. The other thing on this slide was from the original session, which is really just the key mandatory points in the mandatory notification process. Any other comments from the panel before I move on?
Yeah, I think just in relation to that payment question as well, I think that's a real area that breaks down currently in industry. So I think it does cause a bit of friction because quite often I don't think they've been considered or allowed for in the process. And then it sort of creates unnecessary angst at that stage of the project. So I think it's really important at the beginning of the project for all parties to have an understanding of what fees may eventuate as the process continues. Obviously, it's difficult because you can't necessarily provide a fixed fee on these things, that each piece of construction is different. There might be different requirements as you progress through the process. So it is really when you're putting your contracts together and your submissions, making it clear on what's included and what's not, and what the expectations are of the other parties. And I think between builders, owners and engineers, it's very important once again for them to consider the requirements for these inspections and making sure they've got an understanding of that allowance that they should be considering in the process, so that it doesn't cause that tension at a later date.
Yeah, Alicia, do you want to make any points around the scoping and the situation that engineers can find themselves in?
So our recommendation would be that engineers are engaged early in the process and that they're having conversations with the builder, with the registered building surveyor, and clearly scoping up the works and who's responsible for the inspections and how they're going to be paid for, so that it's really clear from the beginning of the project how this will occur. At the end of the day, it's fair that everybody is reimbursed for the work that they undertake, but having those discussions early so that it's clear and it's well scoped will help to mitigate the risk of having harder discussions down the track about who's paying for these.
Yeah, and I guess it all comes back to the first box in the flow chart there, and that is the prescribed mandatory inspections must be listed on the permit. But the more detail that can be put into that list, we talk about a prescribed stage is around in situ steel inspections. I'm trying to describe where on a large project, on a complicated project, a multi-story project, what that looks like in practice will vary. And it's not just simply putting down a single line to say, which members are going to be inspected. There should be a decision early about what inspections, and it mightn't be that in consultation with the engineer about how to actually identify early what those inspections are going to be that the RBS wants included as part of the mandatory inspections, and that agreement that this is the engineer that's going to do it. So all of those checks around who's doing it, is the RBS satisfied with this engineer, can be done early. And then it might be that at that point it becomes copying in the RBS, so long as all of that has been established early on and is understood, and that engineer knows the RBS process for lodging those inspection reports and other things.
And probably the other point I'd like to make too is just the appreciation of the value of inspections in the process as well. That I think there's a lack of that in some parts of industry, that there's some that would like to remove them, just see them as a unnecessary step in the process and something that they'd like to minimise. But if these are being done properly, they're an important part in the process of making sure that we've got complying building work and managing issues down the tracks. That the rectification, as Alicia mentioned before, the rectification costs can be horrendous. So these are all designed to try and have the right people on the site at the right time to manage these potential risks in the construction process. And so we need to really make sure that all parties are aware of that and recognising that value, and really appreciating the input of the right people at the right time on the site.
Yeah, that's a great point, Andrew. Okay, we had a couple of questions around referrals to authorities. So what are the obligations of the RBS when becoming aware of a Section 16B offence, i.e. commencing work without a permit? And there were a few different questions around this. So the examples that were given were where, let's assume it's a private building surveyor is the RBS, they've issued a permit for renovations to a dwelling, and during inspections it's discovered that there's a great big whopping brick wall being built on the front fence, or there's a swimming pool being constructed that's not within the permit. What is the RBS expected to do in those cases? Where it's a completely different structure that's being built, it is not within the private surveyor's jurisdiction. So they are responsible as an RBS for the work for which they've issued a building approval. But that doesn't, of course, mean that you walk off site and say, it's not my problem. You really need to be notifying the relevant local council about this work, and also the VBA. One or both of those authorities need to be made aware that this work's been done without a permit, so that they can consider, and particularly it's going to be the council that is the most relevant authority here, because they're going to be the ones that have the ability to step in and issue a stop work order or emergency order if that's necessary, whereas the VBA doesn't automatically have those powers. So it's important that the RBS is responsible when this sort of situation happens for making sure that there is enforcement action that's taken. It's quite a serious breach. In this case, the questioner referred to 16B, which is the indictable offence. So it's the really serious one where there's a registered practitioner or a building practitioner, regardless of whether they're registered, who's knowingly done this. That becomes an indictable offence. So they're very serious, but the question of whether it's an indictable offence or whether it's one of the other provisions in Section 16 is really one that then it gets investigated if there's to be enforcement action or a prosecution. What the RBS needs to be doing is making sure that there's a notification to the relevant council about it, so that any immediate response can be made, as well as then the longer term investigation and potential prosecution of that breach. And then the other sort of related question, the obligations of the RBS when becoming aware of the Section 33 breach. So this is where the mandatory notification has not been made. The work's progressed beyond that stage. So, for example, the frame inspection's been called, and on arrival, or on looking at the records, there's no record of the footings inspection. So it is mandatory. The Act says that the RBS must notify the VBA when this becomes apparent. And we've got on the screen there some of the references to how to notify. So you use the referrals at VBA email there. And there's also information at the webpage there on what the VBA needs from you in that referral. There's not a template, but there's a clear dot point list of what you need to cover in that email. Andrew, you might want to comment on the activities of the VBA in this area.
Yeah, thanks, Bronwyn. So pleasingly, after the last presentation, we saw a real upkick in regards to the numbers of notifications that we had of inspections, mandatory inspections. So I think we've sort of aligned that to that inspection, that it was almost the day after, and it was a sizable increase, and that sort of continued through. So I think that's a really good thing from our perspective, is that we need those notifications. It's part of the process. It triggers other requirements under the legislation and other opportunities for touch points in the process. The other thing to point out is that there has been a lot more activity from the BBA perspective in regards to reviewing those notifications and following those up from a penalty perspective, and it is a significant penalty for the builders that don't notify when they're meant to. So it's very important for the builders to make sure that they're aware of their notification requirements to the RBS. So sometimes it is this misunderstanding about the RBS role and the requirement to cause the inspection, and so there may be missed communication lines where they've communicated directly with the engineer or other parties to do that inspection, rather than making sure that the RBS is also informed. And that the penalties are sort of fairly significant. They're between $2,000 and $6,000. So one that builders need to really make sure that they're following through on.
Thanks, Andrew. All right, the next topic is inspection records. Some of the questions that we got are on the screen here. The first one, would you issue a direction to fix rather than just a site inspection report? So these are two completely different things. A site inspection report you must issue for every mandatory inspection. So it's issued under 35A, section 35A, and some refer to it as Reg 173 report. That's because in Reg 173 are the prescribed requirements for what goes in that inspection report. So that has to be issued for every mandatory inspection, or even a follow-up inspection that's associated with the mandatory inspection process. A direction to fix is only issued where there's going to be a direction to carry out work to resolve a non-compliance. So you're always issuing a site inspection report, but hopefully you're not always issuing a DTF. And a direction to fix is, in the first instance, in practice, it's usually done orally by an inspector or a surveyor, or the RBS themselves, and then the RBS will issue the written direction to fix. So if you're not sure about directions to fix, there's an extensive practice note on it, and you should also go and have a look at those provisions, and perhaps the VBA might have a dedicated session on DTFs, because it's a really important process, and it is very different to the site inspection report that gets issued. Is a building inspector or authorised person required to provide the report, the 35A report, together with the 238 certificate for each mandatory inspection? So this is a slightly different question. The 238 certificate is not mandatory. However, it's at the discretion of the relevant building surveyor whether they require one of those to be issued by the inspecting inspector, surveyor, or engineer. Now, engineers can only issue them for domestic building work, which I mentioned earlier, and also they're not mandatory, but the RBS might require one. So if you're an engineer and you don't want to issue 238 certificates, this is part of the discussion that needs to be had with the RBS about whether you're going to do the inspections, because essentially the RBS might say, I want a 238 certificate. Engineer says, I don't want to issue one. And ultimately, if the RBS remains firm on that position, they need to find another engineer that will. And so again, if the engineer says, well, I'm engaged by the builder, I haven't agreed to issue 238 certificates under my scope of work. So that might be very well, but it's going to be a headache for the builder, because there has to be someone else then paid to do that inspection who is willing to issue the 238 certificate. So this whole, there was a few questions around, can I be made to issue a 238? Do I have to? All this, these sorts of things. And I think my understanding is that's where this is coming from, that engineers may not want to issue them. RBSs may be insisting that they do, and some sort of happy resolution has to be found. Andrew, did you want to comment on that?
It is an interesting one too, because I'm just sort of thinking now as well as to the logic behind the Section 238 only applying to domestic, and whether that is related to perceived additional risks at that level around the conflict, which I think we might be sort of discussing down the track, that it provides a tool to the RBS that if they are concerned about that conflict of interest between the engineer and the builder, that they can ask for that Section 238, which they then can rely on. Whereas they don't have that same provision for non-domestic works within the regulations. So you don't have that option as an RBS to have a certificate that you can rely on. You can have a certificate, but you don't have that same indemnity that you do with a Section 238. And I think, you know, the other important thing in the process is that even though the building surveyor can't force a engineer or other party to provide a Section 238, they basically can refuse to sort of progress the process. So that, you know, that's really the key thing from the building surveyor's perspective, that if they're not satisfied with the level of documentation or information that they've been provided to allow them to satisfy themselves that the compliance is achieved at that mandatory stage, they can basically ask for another party to sort of do that, have an independent engineer, and once again that then creates issues around the payment side of it, so that you've got, you know, another party sort of coming in and potential tensions around who pays for that. So that's one that you know, is probably a little bit harder to manage, because that's a bit of an unknown in the process, but something that the builders and owners and engineers need to appreciate, that you know, it could eventuate in the process.
Just moving on to the last couple on this slide, what's the time limits around, or the timing required for the record of the inspection? The Act doesn't say, so again, this would be part of what does the building surveyor require. The RBS actually has to lodge information through the BAMS system monthly on inspections, so they do need to be collecting these records to be able to lodge accurate information into BAMS. And I would suggest that the requirement to provide their report should be very timely. Also, because the RBS should be staying on top of any issues that are coming through in those reports that they need to be aware of or clarify or check up on. So it definitely shouldn't be the case that you collect these reports as part of the occupancy permit assessment. They should be being collected throughout, and the RBS should be clear with the inspecting people of the time frame in which they expect those reports to be provided after the inspections. Does a 35A report have the same effect as a 238 certificate? No, it doesn't. Legally, the 238 certificate provides statutory immunity. The 35A does not. But you know, so there is a difference, and as we mentioned under question 2, you know, the 35A is mandatory, the 238 is at the discretion of the relevant building surveyor. In good faith, this is a repeat from the previous session, but there was some questions about what does accepting a certificate in good faith means. There are a couple of cases on this. It's not automatically the case that a certificate provides immunity. It has to be looked at by the relevant building surveyor. They have to be satisfied about who's issued it. Do they have the expertise? Has it been properly filled out? Is there anything on the document that doesn't make sense? So it hasn't referred to all of the approved documents that are relevant or the standards that are relevant to that inspection. It has there's just deficiencies in terms of you know, what is being certified in the certificate. So it's not just a paper shuffling exercise. It does require the building surveyor to look through the certificate, think about it, and be satisfied that that their certification is as intended. Andrew, did you want to comment about conditions that can sometimes be put on these as well?
Yes, I think it's important to also, when you're looking at these certificates, to consider any conditions or assumptions that may have been included on the certificate. So I think there are some in the industry that don't pay the certificates as much attention as they should. That as long as they've got the address and a signature from a registered practitioner, that's the end of the process. But important to challenge any of the wording within the certificate where it requires things that or even excludes things that may not be appropriate, because they will, even though a certificate under section 238 actually provides you immunity, it's only if it's in that good faith. So if there's anything that is included in there as a condition that you haven't followed up on and confirmed in your own mind that that has been met, then that leaves you open.
Okay, the last group of questions is come from engineers or about engineers, and I'm really keen to get Alicia and Bayer involved in these three in particular. And can I start with Alicia, with you just giving just a summary of the new Professional Engineers Act and what it requires in terms of registration?
A very quick overview. The scheme, the Professional Engineers Registration Scheme, was implemented by the Victorian government and came into operation on the 1st of July this year. So it is very new in terms of the operation of the scheme. It does mean that if you are engaging an engineer, you're no longer engaging them as a registered building practitioner. You need to be confirming that you're engaging a registered professional engineer, that they're registered in the area of practice that's required, and that they do have a building endorsement to be working in the building sector. All engineers that were previously registered with the VBA have been deemed across into the new scheme. They've been deemed across in the category that they the class that they were registered, unless they were a civil or structural engineer, in which case they've been deemed across as a civil engineer. So civil engineers or structural engineers are civil engineers, but not all civil engineers are structural engineers. So it is really important that if you are engaging an engineer, that they are competent to undertake the work that you require. For example, a civil engineer is not able to undertake all civil work. They won't be competent to undertake every piece of that work. The 5 areas of registration are civil, structural, electrical, mechanical, and fire safety engineering, which mirrors the previous scheme. And this scheme does apply to all engineers beyond just the building sector. And that's why this piece around making sure that you've got the building endorsed engineer is actually really important. A reminder that registered engineers must only practice in their area of competence. The scheme is co-regulatory, which means that there will be assessment entities such as Engineers Australia, and we will be doing the assessments for engineers to join the scheme, but it is a government scheme, and it will be administered or is administered by the Business Licensing Authority. So for engineers who do need to register, you need to get yourself a MyCav account and join the BLA registered scheme. That, I think, is a really very, very brief overview, Bronwyn. Not going to answer all the questions, but I did put the link into the chat so that people can find that, and we can potentially run a follow-up session with more detail on what the scheme means for the sector. Okay,
great. So we've got 3. Yeah, Bayer, go.
Yes. For structural engineers, for their current status, they have to re-register through the BLA. because they are not going to be transferred immediately into that. There is non-existent structural engineer in the old system of registered building practitioners. Accordingly, if we have a highly complex structure that need to be reviewed by a structural engineer, unless that the civil engineer is renowned and known properly and endorsed for structural works, they have to engage an endorsed structural engineer, and accordingly, please try as much as possible to get yourself registered in this as soon as you can.
Thanks, Bea. Okay, so 3 questions here. We are getting close to time, and these are some pretty meaty questions. So the process for engaging a building endorsed engineer, we have talked about the whole cause to be inspected, but just, Alicia, maybe you want to touch on the importance of the engineers scoping out their work and defining the process for their engagement.
Sure. I think it comes back to making sure that the engineer understands the work, that the full scope is known and discussed, and that those discussions are held early between the registered building surveyor and the builder. There's really good opportunities to look at things like what are the risks in the project, to identify those early, to make sure that they are inspected along the way and given the due consideration that they require as risky parts of a project. And yeah, just getting all those requirements relating to the inspections into the scope early so that the process is known, it's understood, all parties know how they're going to engage together. Bronwyn, you touched on some of the things such as, can the builder engage the engineer directly? Well, that depends on whether that's agreed with the registered building surveyor. So having those conversations up front so that everybody knows how they are going to operate together, and make it a successful partnership to get the outcomes that are the desired, which are good, safe buildings.
Yeah. And in relation to, sorry, go ahead, Andrew.
I was just going to add on that I think that's a really good point too, that I think there's probably a lack of engagement between engineers and building surveyors in that risk assessments, because I think there's real opportunity for more engagement where the engineers actually identify what should be mandatory inspections from a perspective from the engineering, so that they can be listed on the building permit during the process, and they're actually picked up. And I think there's a real lack in many parts of the industry of building surveyors, because they do have the ability to do mandatory inspections or require mandatory inspections outside of those that are prescribed in the regulations, that if there's particular areas of risk or concern, they can actually nominate those in the permit. So I think that's something that your sort of advice around that engagement up front is of value.
And even when it comes to undertaking those inspections, even if the design engineer is not the person who is undertaking those mandatory inspections, it can be worth looping back to them, because they understand what the design intent was. They understand what those risks are that are present, so they can really help whoever is undertaking that inspection to be looking for the right things when they are doing an inspection.
Let's segue into this really important question, and that is where the issue of conflict of interest and whether or not a design engineer can do a mandatory inspection. So as we know, there is a very specific and express prohibition against a building surveyor participating in design, and that's been in the Act since 1994. Since the Act was created, it's been reinforced and described in much more detail in the Building Surveyor Code of Conduct. And of course, the building surveyor is responsible for mandatory inspections as well. And so we did have a few questions through to say, well, how can a design engineer do a mandatory inspection? And if the building surveyor is not able to be involved in design, surely there's an inherent conflict of interest by the engineer doing inspections of their design. Now, the answer is that according to the Act, does not prevent an engineer who has done the design from doing an inspection. There's not a statutory conflict of interest there. And to the extent that there might be a conflict, what the position that I would suggest to you as the reason why governments haven't said that this can't occur is because, firstly, it's the building surveyor still that's causing the inspection. And as we've said a number of times today and at the last presentation, the building surveyor has discretion over this whole process. If they're concerned about a particular engineer having a conflict or not inspecting thoroughly enough or those sorts of things, they can say, no, I want someone different to become involved at this point. So it is still in the control of the building surveyor. Secondly, engineers are professionals. They have a code of conduct. They are supposed to act impartially, and they ought to be able to manage their role as the design engineer when conducting an inspection. Bayer, you might have some comments about that as well in terms of, you know, the role of the engineer when inspecting.
The design engineer would have the probably the best judgment that can be put forward for the satisfaction of the design intent, and whether it was fulfilled in the construction works or not. So they have that ability to immediately identify a problem, and rather than and that would be a kind of an immediate address. It can also, in that sense, either nicely and politely address the matter with the construction team quite early, rather than going into the usual circles of going ahead and filing in report. That does not mean, at the same meantime, they are not bound by providing a full report. They are, but as well, they can pass the information to the construction team, which one way or the other, they have had some sort of engagement early on. So there would be a better method of communication, hopefully. A conflict of interest, yes, if this would occur if really there are too many problems on site. And in this case, it was suggested that in such situation, a direct involvement of the RBS should be undertaken. The RBS should be brought on board as quickly as possible. That would actually make things much easier. And I know that sometimes the engineers might receive a little bit of unwelcome and not that savory treatment because they identified too many problems. But rest assured, once an engineer walked onto the site and they found something wrong, they own it. We have to report it. This is part of our code of ethics. This is part of our code of conduct. So once we stepped in there, we found something wrong. We have to make sure that this problem or these problems are being communicated to be rectified.
Absolutely. And I think another example of that might be where there's an inspection and it's through that inspection that there's a design error that's been detected by that very engineer. And of course, you have to own it and report it. There might need to be an adjustment to the design. There might need to be a consequence. But here's where a conflict is created because, in fact, there's been a mistake and you're no longer independent enough to decide how to resolve that as the engineer. And so this can be quite difficult. I might, be hearing RBS is saying, well, how are we supposed to know if this is going on? This is where the professional obligations really come to the fore of not just the engineer, but the building surveyor that's involved. So it is really important that the engineer comes forward with conflicts of interest, identifies issues that perhaps the builder is unhappy to be told that, in fact, there's an issue that needs a resolution, is going to slow the project down or cost money. The fact is it needs to be resolved and there needs to be a good working relationship with the building surveyor. The other point to make, and I know we're now running out of time very quickly or have already, is that if the engineer's on site doing inspections that aren't mandatory inspections and they are adjusting the engineering design as a result of that, that's a variation to the building permit, and the building surveyor needs to be kept into the loop on that. So it's not just in a mandatory inspection reporting to the building surveyor. If there are other inspections which are resulting in amended design, they need to go to the building surveyor. It's not for the building surveyor to come on site or be chasing amended design late in the process that they weren't aware had been arranged between the builder and the engineer. The building surveyor has control, or ought to be having control, of the process, and the engineer, as a professional and a registered person, needs to be ensuring that the building surveyor is able to record those variations and ensure that the process is followed and that adjustments are being reflected in the approved documents. Andrew, do you want to make any closing comments, or any of our panellists? We are over time, but if anyone has any last comments they want to make, please, now's the time.
No, just in the interest of time, I'd just like to thank you, Bronwyn, and Alicia and Bayer, and also I'd like to thank Amanda Wellesley and the rest of the VBA team in putting together a lot of these education sessions. I'm hoping that everyone's finding them useful, and hopefully you've provided some comments around other things that you might find of value in future.
Thank you, everybody.
Thanks all. Bye.
Thank you.